Making a will and creating a trust are two important steps that everyone should take to protect their loved ones. But what is the difference between wills and trusts, and which one is right for you? In this video, we will explore the key differences between wills and trusts to aid you in your decision. So first, welcome back to the Beast in Your Fire Journey channel. I'm so happy you can make it, and welcome to those who are new as well. And throughout our journey, we've learned a lot about investing, saving, and managing money. So I hope that today's video will be helpful for you. And if so, please give that lonely like button some love and subscribe for more for our financial journey. So what is a will? A will is a legal document that allows you to control how your property and assets will be distributed after passing. You can use a will to specify who will receive your property and assets, design a guardian for your minor children, appoint someone to manage your estate. Creating a will is one of the most important things you can do to protect your family and yourself. If you die without a will, the state laws will determine the distribution of your property. This could be a scary prospect because it may not be as you wished. Additionally, if you have minor children, the court will decide who will care for them if you do not designate a guardian in your will. While it is important to have a will, it is also important to keep it up to date. My wife and I love to periodically check our will to make sure everything is up to date and ensure that it accurately reflects our current wishes. You may also want to consider updating your will if you experience a major life event. For example, if you plan on getting married, having children, or buying a new home. If you have any questions about creating or updating a will, you should consult with an experienced estate planning attorney. An attorney can help you understand the laws in your state and ensure the proper execution of your will. Contacting an attorney early on in the process can also help you avoid potential problems down the road. The process of creating a will may seem daunting, but it's definitely worth looking into. It's essential to take the time to ensure that your wishes are carried out after your death. By taking some simple steps, you can give yourself and your loved ones peace of mind. Knowing that your affairs are in order will give you a sense of relief. An attorney can always help you understand laws in your state and ensure that your will is properly executed. Contacting an attorney early on can help you in the process to avoid potential problems down the road. So what is a trust? A trust is a legal arrangement in which one party, the trustee, holds property or assets for the benefit of another party or the beneficiary. Trusts can be created during one's lifetime or after their death. There are many types of trusts, but they all have one purpose: to provide financial security for the beneficiaries. So the terms of each trust are unique and can be customized to fit the needs of the grantor and beneficiaries. Trusts can be used for many things such as estate planning, asset protection, charitable giving, and tax planning. The best type of trust for you depends on your specific goals, objectives, and the assets that you own. When creating a trust, it's also important to consult or at least run it by an experienced attorney. He or she can help you choose the right type of trust for your needs and draft the necessary documents if you need that. Trusts are complex legal documents. It's important to have professional guidance when creating one. So here are some key differences between wills and trusts. There are a few key differences between these two that you should be aware of before making your decision. For one, wills must go through probate court, while trusts do not. This can mean a longer wait time for your beneficiaries to receive their inheritance as well as added costs. Trusts offer more flexibility in terms of how and when your assets are distributed, whereas wills are more straightforward. Another significant difference is that wills are public records, while trusts are not. The benefits of public records is that it increases the transparency of the process. Also, it can deter potential challenges to the will. The privacy afforded by trusts may be appealing to some, but it also means that there is more potential for abuse. Abuse can happen through trusts because there is less oversight and accountability. Lastly, trusts can be revocable or irrevocable, while wills are always revocable. This means that you can change your mind about a trust, but not about a will. What does this mean for you exactly? If you're still uncertain on which route to take, it's not a bad idea to consider speaking with an experienced estate planning attorney. Doing so can help you weigh the pros and cons of each option and make the best decision for your unique circumstances. In the meantime, here is a more in-depth explanation of each option. So will versus trust, which is better? There's really no easy answer when it comes to choosing between a will and trust. So here are some general things to keep in mind when making your decision. A main reason to get a will is that it is simpler and less expensive than setting up a trust. If you don't have a lot of assets or you have a small estate, a will may be the better way to go. This means that anyone can challenge it in court, but it also deters potential challenges when the challenger would have to go through the public processes. You should at least have a will because it provides that peace of mind and will help your beneficiaries. Additionally, it can save your loved ones a lot of time, energy, and money. A will provides clear legal instructions for where your assets will go when you die. Having one helps you avoid costly and time-consuming processes of probate court. So a trust can offer more protection for your assets than a will can. If you have a lot of assets or you're worried about creditors, lawsuits, or estate taxes, a trust may be the way to go. Creditors can take your assets after you pass on by going through probate court, but they can't touch your assets that are in a trust. Taxes also are less of an issue with trusts. This is because the assets in a trust are not subject to estate taxes when you die. If you don't want to be in a position where your family may have to go through court, a trust may be a better option for your loved ones. Obtaining both a trust and a will. If you want to get the best of both worlds, you can get a trust and a will. This way you will have the simplicity of a will for your small estate and the protection of your trust for your large estate. For example, you can use a will to leave your house and other assets to your family, and you can use a trust to protect your money from creditors, lawsuits, and estate taxes. This can help ensure that your wealth goes to people you love rather than being taken by the government or creditors. You can also use a will to name a guardian or your minor child and a trustee for your trust, which can provide peace of mind for you and your family. If you're still unsure, make sure to do some more research, and you can always talk to an experienced estate planning attorney. If you do not have a trust or will, I highly recommend to get started now. You can benefit from both of them. The key takeaway is that you should be thinking about how to create generational wealth and how to securely pass that down for your loved one for generations. So begin today and make sure that your legacy continues. Have you already set up a will or trust? If so, leave a comment below and give your feedback or thoughts on it. And make sure to subscribe for more content to come.